A British Columbia court just ruled that Aboriginal title can override private property rights, and homeowners across Canada are starting to panic. On August 7, 2025, BC Supreme Court Justice Barbara Young issued a landmark ruling in Cowichan Tribes versus Canada. After a 513-day trial, the longest in BC history, the court found that Cowichan Tribes hold Aboriginal title over 732 acres of land in Richmond, British Columbia. The Aboriginal title ruling declared that fee simple titles, the strongest form of private property ownership granted by the Crown and City of Richmond, are defective and invalid. This Cowichan Aboriginal title case is the first time a Canadian court has said Aboriginal title can potentially invalidate registered private property. Here's what makes this Richmond Aboriginal title case so explosive. The Cowichan Tribes are from Vancouver Island, but they claimed Aboriginal title to land on Lulu Island in Richmond because their ancestors used it as a summer fishing village. The court ruled the Cowichan had exclusive occupation of Tl'uqtinus village before 1846, when British sovereignty was asserted. Hudson's Bay Company officials recorded 108 longhouses there in 1824. But colonial authorities never created an Indian reserve. Instead, they sold the land starting in 1871, creating what would become fee simple private property. The Cowichan Aboriginal title claim covered 1,846 acres. Justice Young granted Aboriginal title to 732 acres, about 40% of what was claimed. That includes City of Richmond property, federal government land, Vancouver Fraser Port Authority facilities, and private industrial, commercial, and residential properties. The Aboriginal title decision affects Amazon warehouses, IKEA distribution centers, Riverport Sports Complex with movie theaters, and bowling alleys, and an industrial park developed by Montrose Properties worth hundreds of millions of dollars. Now here's where the confusion starts. The Cowichan Tribes say they never sought to invalidate private homeowner titles. Their Aboriginal title claim targeted only Crown land and city property. But Justice Young's ruling said Aboriginal title and fee simple title can coexist on the same land, even though both are exclusive ownership rights. Legal experts call this logically impossible. You cannot have two parties holding exclusive rights to the same property. The Richmond Aboriginal title ruling creates what lawyers describe as an unsettled relationship between Aboriginal title and private property across Canada. Richmond Mayor Malcolm Brodie hand-delivered letters to 150 property owners warning the Cowichan decision could negatively affect their titles. The City of Richmond is appealing, arguing Aboriginal title and fee simple title cannot coexist. British Columbia, Canada, and Musqueam Indian Band are also appealing. Musqueam claims they hold Aboriginal title to the same Fraser River lands, creating competing Aboriginal title claims between First Nations. The economic impact is already happening. A Richmond councillor reported that a $100 million development project was denied financing because of uncertainty over Aboriginal title. Montrose Properties, which owns 477 acres in the claim area, is asking the court to reopen the case. They argue private landowners should have been parties to the Aboriginal title litigation that now affects their property values and development rights. Constitutional law experts warn the Cowichan Aboriginal title precedent could affect millions of fee simple properties across Canada wherever Aboriginal title claims exist. That includes British Columbia, Ontario, Atlantic provinces, and parts of the prairies. New Brunswick faces Aboriginal title claims over the entire province by two Indigenous groups. The Richmond Aboriginal title case forces courts to answer whether Canada's land title registration system can guarantee property ownership when Aboriginal title exists. Premier David Eby says BC is working closely with Richmond on the appeal. The Cowichan Tribes call political statements about private property threats deliberately inflammatory and misinformation. They insist the Aboriginal title case never challenged individual private landowners. But the legal reality is that Justice Young declared Crown Grant's creating fee simple title unjustifiably infringed Aboriginal title, opening questions about every property transaction in the claim area. What do you think about the Cowichan Aboriginal Title ruling? Can Aboriginal title and private property coexist? Drop your thoughts below. Subscribe for updates on this Richmond Aboriginal Title appeal and how it could reshape property rights across Canada.